Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention. The Court is now sitting. God save the United States and this Honorable Court.
We'll hear argument this morning in case 1946, United States Patent and Trademark Office versus Booking.com. Ms. Ross?
Mr. Chief Justice, and may it please the Court, it is a fundamental principle of trademark law that no party can obtain a trademark for a generic term like wine, cotton, or green. As Judge Friendly explained, and as the Lanham Act confirms, a generic term is never entitled to trademark protection, no matter how much money and effort the user has poured into promoting the sale of its merchandise and what success it has achieved in securing public identification. In other words, secondary meaning or acquired distinctiveness is simply irrelevant to generic terms. That principle controls here. It is undisputed that Booking is generic for the hotel reservation services respondent provides. Respondent thus could not federally register Booking, nor could respondent register Booking Company or Booking Inc. In Goodyear, this Court held that the mere addition of an entity designation like Company or Inc. to an unprotectable term does not create a protectable mark. That is because those terms indicate only that parties have formed an association or partnership to deal in the relevant goods. By prohibiting a first adopter from obtaining a trademark in a phrase like Booking Inc., Goodyear ensured that no party can monopolize a generic term. The same result should apply to Booking.com. The addition of .com is the online equivalent of Company or Inc. It conveys only that it provides its services via a commercial website on the Internet. There is no sound reason for respondent to be able to federally register Booking.com as a trademark when it couldn't register Booking Inc. Registration would effectively give respondents a monopoly on the words Booking.com and would interfere with competitors' ability to use similar domain names. That's particularly problematic because of how the Internet works. Only one entity can obtain the contractual rights to a domain name at a time. So respondent already enjoys significant competitive advantages that brick-and-mortar equivalents of Booking Inc. would lack. That same feature of the Internet also means that if respondent survey evidence is enough to obtain federal trademark registration, then nearly every generic .com can do the same. Because domain names are one of a kind, a significant portion of the public will always understand a generic .com term to refer to a specific business, even if it is not familiar with the particular business at issue. That result is
Counsel, you mentioned the Goodyear case, but you did not quote the language from the trademark statute that is at issue here. That language says that the primary significance of the mark to the public shall be the test for determining whether the mark has become generic. Now, the Goodyear case had a different test, an absolute rule. And it seems to me that in trying to decide what Congress had in mind, it makes more sense to follow the language that Congress chose in the statute rather than a 130-year-old case of ours.
So, Mr. Chief Justice, 2 points on that. The first is that the Lanham Act actually preserves a distinction between generic and descriptive terms. And so generic terms, it confirms, and this is both in the definitional provision and then again in section 1025E and F, or 1052, excuse me, and F, confirms generic terms are never susceptible to trademark registration even when they acquire secondary meaning. And descriptive terms, merely descriptive terms, may acquire trademark significance when they acquire secondary meaning. So I think the Lanham Act preserves sort of the underlying principle of Goodyear. Now, moving to Section 1064.3 specifically, the cancellation provision that you note, that's on page 11A of our appendix. It says the primary significance of the registered mark to the relevant public rather than purchaser motivation shall be assessed determining whether the registered mark has become the generic name of goods or services. I think it's significant here that that provision was enacted in 1984. Respondent has pointed to no case and no source before its own brief, suggesting it overturned this decision in Goodyear.
It was enacted in 1984. that's a lot closer to today than the Goodyear case, which was 130 years ago. So I don't know why we would focus more on the statutory language than that old case. But more to the point may be that if this is a generic term, booking.com, that means that it describes a category of goods or services. But when you talk about other companies in that category, whether it's Velocity, Priceline, or whatever, nobody refers to those as booking.coms. So booking.com is not a generic term to describe that type of service.
So again, a few points on that, Mr. Chief Justice. The first is that we agree that in an ordinary case, one might use the term generic to refer or to understand it, how the consumers generally refer to a class of goods, but I think it can also be used, as this court's decision in Goodyear used it, for how a specific entity or how the public would understand a specific term. So, for example, in Goodyear, the court held that Goodyear Inc. could not be, or Wine Inc., for example, could not be trademarked, and that's true even though nobody refers to a class of wine incorporated. The point is the distinction.
Thank you, counsel. Justice Thomas?
Yes, Ms. Ross, a couple of questions. Could Booking acquire an 800 number, that's a vanity number, 1-800 Booking, for example, that is similar to, for 1-800 which is a registered mark?
So, Justice Thomas, under the Federal Circuit's decisions, yes, it could. Those decisions, I think, are sort of debatable under Goodyear and the principles that we think control here, but the Federal Circuit, the PTO rather, does follow decisions because of the right of direct appeal to the Federal Circuit from PTO decisions. Now, I think it's significant that those are distinguishable in the sense that the core problem with Booking.com is that it allows respondent to monopolize booking on the Internet because of the fact that longer domain names of its competitors like ebooking.com and hotelbooking.com can include Booking.com. It's not as obviously true of something like 1-800 Booking.
Well, that could be true, but I'd like you to compare this to Goodyear. In Goodyear, you had a generic term, but you also had added a term such as company or Inc., which any company could use. Now, with Booking, here, there can only be one domain address, .com. So this would seem to be more analogous to the 1-800 numbers, which are also individualized.